I've been asked to do this. We're going to start at, I suppose, a quick reference to the Mulmuteen laws of England, which are 450 BC basically. A set of 7 very basic laws that effectively were predicated on the do no ill mentality. They were the first laws of England. We come forward a bit to 1383, 8th of June 1383, and there was an interesting juncture in time when the King of England is recorded. It's very well documented. The King of England gave the land and the pertinences thereto in the kingdom, which at the time was the whole of the Trinity, England, Scotland, Wales. The 3 kingdoms came under the King of Wales on the 8th of June 1383. King of Wales at the time, his name was John Fawley, his wife's name was Helen. So from that point on, the title Lord High Constable was vested in the King of Wales. That meant the Lord High Constable, constabulary being the law of the land and the authority of the land, the lands were governed by the King of Wales and his male-born offspring. The Lord High Admiral, that position was taken up by the then King of England. We move forward a bit, we come to 1701, and there was an act, or 1649, Charles I lost his head. Then there was a bit of a kerfuffle about who and how they were going to have a king or a queen or a monarch of any sort. And in 1701, the Act of Settlement 1701 UK came about, and what was created was a thing called a constitutional monarchy. Now that meant that the monarch, the king or the queen, was there by virtue of a law created pursuant to the Constitution of England. That law said that, in paragraph 7, that the Crown was not to take its sovereignty outside the dominions of England, Scotland or Ireland without the consent of the Parliament. So there was a very, very clear limitation on what the sovereign could do with his or her sovereignty. They were not allowed to take it outside of England, Scotland or Ireland without the express consent of the Parliament. Now, given that we're talking about Admiralty law, the Parliament would have to give its consent in writing. And that doesn't mean that consent can be assumed. It had to be given in writing before it existed. Without consent, there was no lawful extension of sovereignty outside of England, Scotland or Ireland. What happened though was that the Crown thought that it would just, and the Crown's admirals thought that they would just continue to conduct themselves in their normal and standard belligerent British manner, and they continued to ignore the law that required them to maintain the sovereignty of the Crown within the 3 dominions. In 1788, a chap by the name of Arthur Phillip arrived in a place now called Sydney Cove, and he put a stick in the ground with a rag hanging off it, and he claims that it is claimed that he claimed the whole of the continent that people refer to as Australia for the Crown of Great Britain. Now the problem with that is that there were a couple of hundred or more sovereign nations on this continent, and all that Arthur Phillip did at best was maybe claim sovereignty over the lands of the people whose lands he put the flag in. All other mobs remained sovereign. They didn't even know that this knuckle had arrived on this continent, let alone that he was claimed to take sovereignty. Now we've also got to remember that when Arthur Phillip came here, he had a commission of instruction that instructed him that he was not to interfere with the rights of the Indigenous peoples, the native peoples. So by claiming sovereignty, he was immediately breaching his orders, which meant that he was acting unlawfully. Nothing done in breach of law can be deemed to be lawful. There can be no lawful benefit gained from it. So that negates any authority or benefit, legal benefit, that could be attributed to the Crown or its agents as a result of Arthur Phillip supposedly taking sovereign title or radical title over the Aurora people's lands. Now, after that occurred, there was an interesting little juncture. On 8 years after Arthur Phillip is claimed to have taken sovereignty over all of the lands here, the Judge Advocate General of the First Fleet, David Collins, is recorded in his journal as having made an entry in 1796 that he was sitting down on a few occasions and had spoken to Bennelong, and Bennelong had explained to him how that the original peoples had their own system of sovereignty and they had their own system of title to their lands, and their system of title to lands was a hereditary title. In other words, they could give their land to whoever they wanted to give it to, and then upon their death that land became that person's land. David Collins' journal records that Bennelong told him that he was going to leave his lands to his best mate, whose name was Bygone. In Judge Advocate General Collins's journal, he also recorded that in 1796 the Aboriginal people maintained their hereditary title over their lands. Now, if Arthur Phillip, as the Crown of Australia would tell you, that Arthur Phillip took sovereignty and radical title over the whole continent in 1788, how is it that 8 years later someone in a contemporaneous document wrote that the original people still held their hereditary title to that date? What makes a further mockery of the Crown's claim, and the reason I call it the Crown's claim is I have a letter from the Federal Attorney General's office stating that in 1788, when Arthur Phillip put the flag in Sydney Cove, that is when they claim, this is their claim, this is their legal claim, they claim that is when the Crown took sovereignty and radical title over the continent. So, our first piece of evidence to counter that and to prove that lie is Judge Advocate General Collins's journal entries from 1796. Between 1836 and 1840 there was a Commission of Inquiry in the House of Commons, and that Commission of Inquiry was looking at the interaction between British settlers and Aboriginal people. As a matter of fact, from memory, the Commission of Inquiry was entitled a Commission of Inquiry into Aboriginal peoples wherever British settlements were made. Now, the documents that are the record from that inquiry clearly show that there was much argument about whether or not at some point in the future the Crown could extend sovereignty into the British colonies, whether or not they had to treaty with the native peoples, and whether or not it would be lawful, if they could extend their sovereignty, whether or not it would be lawful to take jurisdiction over the Aboriginal people. There is no question whatsoever, if you read the transcripts or the documents available that relate to that Commission of Inquiry, there is no doubt that sovereignty had not been taken, and the Crown and the Parliament had not considered itself to have taken sovereignty over the colonies at that stage, or the lands on the continent. There was a number of things going on by the late 1800s. There was a number of things going on in the Pacific Ocean, including the relocating of Kanaks from the Pacific Islands to the cane farms in northern New South Wales and Queensland. The Crown got a wind of this, and in 1872 they created the Pacific Islander Protection Act, which detailed how that the people, the vessels that were, and the captains that were transporting workers were to carry bonds and hold a bond in relation to the passengers, and there had to be a manifest of the passengers, and there could be no slave trading. Because the admirals, under their Admiralty law, and bearing in mind that Admiralty law is the law of the sea, it is not the law of the land, the admirals continued to ignore the Parliament's instruction and continued to breach their own parliamentary instruction and their own law, and they continued to slave trade in the Pacific. In 1875, there was an amendment to the Pacific Islander Protection Act in order to clarify and make more easy to understand the intent of the Parliament. Section 6 of that amendment, and I'll read it to you so that we get it right. Section 6 of the amendment is titled "Power for Her Majesty to exercise jurisdiction over British subjects in the islands of the Pacific Ocean, and to erect a court of justice for British subjects in the islands of the Pacific, and to make ordinances." And it goes in, it says, "It shall be lawful for Her Majesty to exercise power and jurisdiction over her subjects within any islands and places in the Pacific, and the Act clarifies the places as being the Australasian colonies in the Pacific Ocean, not being within Her Majesty's dominions, and Australia wasn't a dominion at that time, wasn't classified by the Crown as a dominion. And it says that she could go and do certain other things. It shall be lawful for Her Majesty, by ordering council, to create a court of justice with civil, criminal and admiralty jurisdiction over Her Majesty's subjects within the islands and places. You know, and it keeps talking about how she had jurisdiction over British subjects. The reason for that is all orders given under letters patent only apply to British subjects, because the letters patent do not apply to anyone else, and the letters patent is the authority that the Crown, by which the Crown vests authority. The interesting part, though, of that whole act, that whole amendment, is Section 7. Section 7 is called the saving of the rights of the tribes. Nothing herein, or in any such order in council, or any law, shall be construed to extend, to invest, shall extend or be construed to extend, to invest Her Majesty with any claim or title whatsoever, to dominion or sovereignty over any such islands or places, and the islands being the Pacific Islands and the places being the Australasian colonies, or to derogate from the rights of the tribes or people inhabiting such islands or places, or of the chiefs or rulers thereof to such sovereignty or dominion. In other words, the Crown was specifically statute barred, or barred by this law, prohibited by this law, from extending or construing to extend sovereignty or dominion into the Australasian colonies or Pacific Islands. Now, when the British settlers here decided that they needed to form some sort of a conglomerate to look after themselves, they created this thing called the Commonwealth. And in doing so, they held a number of constitutional conventions, and they settled on a document, and the document was later called the Constitution. But when that document was sent to the Home Office in London, it was amended, and there was a couple of things added to it. And one of the last two passages to go into the Constitution, Section 127, stated that the Aboriginal natives were not to be counted as a part of the population of the Commonwealth of Australia or any part thereof, so any of the states or territories. The reason for that was that the Pacific Island Protection Act amendments of 1875 was still law, and that law, being the oldest law, had to be obeyed by the subordinate law, being the youngest law. And the youngest law, being the Constitution of the Commonwealth of Australia Act, that law had to include a reference to the original people and a reference to our continuing and ongoing sovereignty. Since 1900, or Federation, the thieves who are the ministers within the parliaments of both the states, territories and the Commonwealth itself have used the position of the Commonwealth to unlawfully usurp the sovereign status of the original native peoples and attempt to exercise a form of parliamentary sovereignty, which was their ultimate goal. It's taken some 110 years nearly to pull this scam off, but they have, by way of manipulation of the Parliament, they have created a corporation called the Commonwealth of Australia and the State of New South Wales and the State of Victoria, etc., etc. And all these brigalow corporations are merely fronts for slave traders, who are the ministers and the others who are a party to that scam, that corporate Commonwealth and state scam. The Aboriginal people have never ceded sovereignty. Our people will not cede sovereignty. In 1967 there was a referendum, and all of the British subjects who were here in Australia on this continent, they voted to amend their constitution, the law that makes reference to them, and they decided they would remove from that law a passage of text that made a reference to the original peoples. They're removing a section of their law, in as much as that section spoke about the sovereign native peoples. That removal of that section does not remove from the native peoples their right to sovereignty over their lands and themselves. That is a fiction that has been put forward by the Crown and the parliaments of the Commonwealth and the states and territories to fraudulently usurp the sovereign status of the original peoples. That is all that has happened. The Commonwealth of Australia is a corporation registered in the Securities Exchange Commission in Washington, DC. It is a corporation that holds slaves. It's like the corporation of the state of New South Wales, who holds its slaves through their birth certificates. That's another story. It's not too involved, but it's a different story, and I can't go off on that tangent. But suffice to say that the only hope that Australians have, and I love my land, but I hate the connotation of the word Australia, because to be an Australian means that you are owned by the Commonwealth of Australia and you are therefore a slave. We are not the free country. We are quite the antithesis of the free country. We're not the lucky country anymore, because our parliamentarians have stolen our birthright and they have squandered it. Stop and consider it for a second. Our government isn't selling our natural resources, or isn't borrowing against our natural resources. They are selling our natural resources to the highest bidder. So when they borrow, what other stock and chattel do they possess that they can borrow against, other than your and my ability to work? That means that they're borrowing against our sweat. They're borrowing against us. They can't borrow against us if they don't own us. You think that they don't own you? Explain to me then why it is that docs can come and take your children. Explain to me why they can take your children if they don't own your children. Why can they force your children to attend a schooling system that they know is doing nothing other than dumbing our children down? Why is it they can force you to mass medicate your children and yourself if they don't own your children, if they don't own you? How can a parliament, if you're a sovereign person, how can your parliament tell you what to do? And if you are a sovereign person, when are you responsible for your own actions? If someone else has to take that responsibility and dole that responsibility out to you through a court. Under traditional law, things were dealt with much quicker. They were dealt with on the spot. We need to go back to our law. If there are people who don't wish to come with us, okay, fine, not a problem. But it's about time in this country. Australians boast that they like the truth and they want to live on the truth and live under the truth. Well then, the truth is that the British law that currently is resident in this land is a fraud. That all those people who uphold that law are upholding a fraud. It's clear fact. Show me the document. Show me the document that ascribes title from this land to the British. Their own law prohibited them from taking it. Their own laws prohibited them from extending their sovereignty into this land. So how did they bring their sovereignty here, under what lawful mechanism, and by what certificate or instrument of title did they gain title from our elders, from our ancient peoples? How did they do this? Surely, if this happened legally and lawfully, there is a record of it somewhere. Who has got that record? Can we please see the kangaroo skin with the iconology on it that shows where our people, in full knowledge of what they were doing, handed over authority over our lands? Because the laws of England prohibited the English law from being brought into this country. And if you want to go into their courts, into the British courts, their law is their Bible. That is where their law comes from. And if you doubt that, consider this. We have God, the Archbishop. The Archbishop coronates or ordains the Queen, gives her authority to be the Queen over the Parliament, who presides over the law, create the law that the courts exercise with the assistance of the police, who control the people. Now, if you don't think that you're living under a secular religious law when you live under British statute law, then you can't see the wood for the trees. The fact is that all British law is church law. It comes from the Church of England. The Queen is the keeper of the faith. Yeah? How can she be the keeper of the faith looking upwards to her God, whilst not at the same time looking downwards and using her status as the keeper of the faith to maintain control over the people through the Parliament and the courts? It has to be a system of Christian religious law. If you are not a Christian, If you are an original sovereign person, you are not subject to that ethos. You are not subject to that church law. If you are not a Christian, period, just not a Christian, you are not subject to that law. And it's about time that the Christians really realise that if they are so full of peace and love and understanding, and that their God is so all high and mighty, surely they would understand that their own law says, when you go into someone's country, obey the law of the land until that law transgresses the law of God. Our laws are based on the precedent of do no harm. The laws of the Bible are based on a very similar precedent of do no harm. So can you explain to me how it is that our law, the law of this land, which was obviously the law before the the British brought their Christian law with them, why is it that our law has been overridden by a law that says that their overriding law can't override our law if our law doesn't offend their law? Which sounds a bit complicated, but I'll put it another way. How can they bring their secular law here when their law says they can't bring it here if our law doesn't offend their law? And our law does not offend their law. Now, might sound a bit convoluted and a bit tricky, but it's not. It's really very simple. Another problem that we have in this country is that we have the federal courts in this country handling a thing called native title. Now, before native title was
This is other issues.
yeah. Actually, what I'll do is I'll get back onto this. Actually, and come back to native title shortly. Now, getting back to the issue of the King of Wales. A lot of people might scoff at the idea of the concept of the King of Wales, but can you explain to me why then that the English royal family named their firstborn son the Prince of Wales at the age of 21? Because under ancient law, at the age of 21, you become old enough to hold title over land. And the interesting thing is that once you're able to do that, you can then act in a particular capacity. The Prince of Wales is given to the firstborn son of the English crown because they can't issue him the title of King of Wales, because the title of King of Wales is not only held, it has been held by the Foley family since well before the 8th of June 1383, and it was since that date that the Crown of Wales held authority over the lands and the pertinences. Yep.
I might do this if it's down a bit.
Right. Now, getting back to the issue of the King of Wales, there's always questions of why the firstborn son of the English King or Queen is granted the title at the age of 21 of Prince of Wales. The Prince of Wales isn't the king. They can't give him the title of King of Wales, because then the question will be asked, where's the title been? And who is the King of Wales? And who has a right to title of King of Wales? The fact is that the King of Wales is still from the Foley line, is alive today, alive, well and kicking, and has challenged the Queen of England in respect of the Queen's jurisdiction as the Lord High Admiral, in respect of the application of her law in the colonies, when he is in fact the King of Wales and has jurisdiction over the lands and the pertinences thereto in the kingdom. So if there is an authority, pardon me, if there is an authority in respect of the title of King of Wales, which there is, and if that title carries the authority of the Lord High Constable, or the highest, the highest Lord in respect of land or law, then the King of Wales has a right to acknowledge or otherwise the claim of sovereignty by the Crown in respect of this land for the Crown. Now, the King of Wales has challenged the Queen's jurisdiction by way of royal proclamation, and on the 4th day of April 2007, His Royal Highness Prince Regent Geoffrey Ross Foley, who is the King of Wales, filed with the Parliament of the United Kingdom and forwarded to all governments, and to, in particular, the governments of Australia, this document here. Now, this document is a royal proclamation. As you can see on the foot of each page, it is embossed with crown seals on the foot of each page. Yep, on the foot of each page, royal seals, They're embossed, no mistake. This document is a royal proclamation. It says the Pacific Islands Proclamation of Independence and Sovereignty. And this document here acknowledges the provisions of the Pacific Islander Protection Act Amendments 6 and 7 of 1875, and acknowledges the fact that the Pacific Islander peoples and the natives from the Australasian colonies, including New Zealand, retain their sovereign status and sovereign rights and the right to practice their own law in their own lands. This document, which I might also add, is sealed by crown seals, crown stamps and signature, and it's signed by His Majesty King Geoffrey Ross Foley, King of Wales, Prince Regent Geoffrey Ross Foley of Britain, and Lord High Constable and Magistrate Lohaden Palace, Lohaden administering St David's Cathedral and St David's Society Worldwide, Pembrokeshire, Wales, Pembroke, Wales. These stamps are all crown stamps. As you can see, crown stamp, crown stamp, crown stamp, crown seals in accordance with law. And this document clearly proclaims that not only did the Crown of England never have, or the Parliament of England never have any authority to extend its claim of sovereignty into this land, but that claim of sovereignty is specifically refuted by the person who has authority and jurisdiction over the lands within the kingdom. And if the lands of Australia were somehow taken for the kingdom, the king of the land has said that that sovereignty was never extended lawfully into this land. None of this has been challenged. As a matter of fact, when I sat down with Mr. Arthur Sinner-Dennis, who was John Howard's Chief of Staff at the time, at a cafe called Bar Luca in, I think it's 68 Phillip Street in Sydney, and I put these documents in front of him, he said the advice that they had received from the Queen was that the Australian government and courts were to vitiate or ignore any of these proclamations. Not that they didn't acknowledge them, just that they were going to try to ignore them. And the message I got was that the Australian people are too dumb to wake up and smell the roses, let alone get their heads around the facts. I don't believe that. As a matter of fact, I think that the Australian people are starting to wake up and they're starting to see the fact that we're not the lucky country anymore. We're not free. We are slaves. You can't even walk up the road without getting pinched if you haven't got a dog on a leash. You can't ride a push bike. If you haven't got a helmet on, you ride a push bike. For some reason, they believe that they can fine you. Like, it's ludicrous. I can understand we need laws to stop crime, but it is not a crime to ride a push bike without a helmet. It is not a crime to walk your dog up the street without a leash. And whilst they're busy fining us for walking our dog up the road without a leash, there's some very, very ugly crimes that senior members of Parliament are getting away with. Crimes that are related to deaths of people. Crimes that are related to the disappearance of children. Crimes that are related to pornographic acts with children. But we won't see any of this getting tabled in the media. Maybe one little snippet here and there. If someone in one of the parties buckles out of line, they'll stitch him up by saying he's done something and produce a little bit of evidence, enough for the public to be gullible enough to swallow. That's about the only time it gets addressed. Australia, it's time to wake up. Simple as that. The time's come. All the proof is here. We have all the proof we need. We can prove that they've been deceiving us from day one. Every word they've used against us, in the English language has been truncated so that we don't fully understand what we are saying. We walk into court or we get dragged into court. When we get into court, they use words against us. We think we know what they're talking about, but they don't. For example, when you walk into court and you're asked, do you understand the charges? The minute you say yes, you're saying that you stand under those charges. You will accept them. We get dragged into adhesive contracts that we don't even know that we're being a party to. But we get dragged into these contracts so they can keep us in servitude and slavery because we have to go to work to pay the bills. Wouldn't it be nice if we could just go to work the 3 days a week that we have to go to work to get the money we need to survive without going through the bullshit we have to go through to work the other 3 days just to pay back the government some of what it's already taken off us? It's not good enough. And it's about time that the governments were made known that these people get elected by us, to represent the community, and they then turn around and describe themselves as our leaders. I don't think so. Kevin Rudd's never been my leader. I haven't needed a leader since I was old enough to get out of my nappies. I've been responsible for my own actions, and I've been man enough to stand up and do what I have to do to be honourable in the face of trying to be forced to be dishonourable and accept the lie. I'll stand up and be honourable, and I'll fight for the truth. And that's part of my right. I don't think that Australians need to sit down for much longer and swallow the crap that we're being fed. It's time to wake up, Australia. It really is time. Anything else? Something else that was just mentioned to me is the issue of Department of Community Services. It's called in New South Wales, or well, I'm not sure what they call it in all the other states, but they've got the same beast, just under a different name. These people, what docs do in New South Wales, I'll give you a perfect example, is if the government has a particular set on your family because you won't immunise your children because they think you should, or because you want to homeschool your children and teach them the truth as opposed to the crap that the government wants fed down their throat, or any one of a number of reasons, docs will come and steal your children. They'll do it on the basis, they'll walk into court, they'll say they want an emergency protection order. They'll walk into court with a bundle of documents, and a federal court magistrate will have 30 applications that need to be heard on the morning. They'll walk into court with documents piled this high and say, we need an emergency application to take these children. The court doesn't have the time to sit down and go through all the information that's being presented. The court must rely on the integrity, which is, I'll use the word very loosely here, the integrity of the solicitors and the barristers and the caseworkers and other members of staff, doc staff, telling them the truth about what the situation is. But what happens is the docs officers who just want to take the child away from the parents, for any one of a number of reasons, walk in, they get a pile of documents, slap them on the counter of the court, the bar table, and they say, we need an emergency protection order to take these children. Now, I know of one case that I can't go into the details of, but this is what happened in the case. The information used to take possession of the children was fraudulent. And what happened was that, and I can't go into that case, but I'll describe the general modus operandi of docs. What they do is that they will bluff the court into giving them access to children so that they can, for example, if the Department of Education want these children in public school, for example, and the children are being home taught, and they're being taught very, very well. They're being educated probably, I would suggest in most cases, above the standard that the public education standard is. The Education Department will use docs to make an application to take the children away from the parents so they can put them in foster homes so they can be put into school. So they're then in the system and it's hard to get them out. Docs will do all sorts of things to keep the children away from the parents because there's a whole industry. They talk about the black industry, for crying out loud. You want to have a look at the docs industry. Have a look at what people are being paid to be carers for these children. And it's always the same people. And have a look in Victoria. We've got all these people that are supposedly carers and they're known pedophiles. They're known abusers of children and the department hands them over. No police checks, no nothing. Oh, she's right, Jack. Pardon me. And it's not good enough. This Department of Community Services, and whatever they're called in every other state, are laundering children. They're taking children away from their parents. In most cases, the parents don't know how to fight the matters in court because the courts are working hand in glove with the departments. There's a lot of money changes hands in amongst this process. There's a lot of money. Have a look at the DOC's budget. Have a look at how much is spent on paying foster parents and carers. Have a look at how many children are being abused in the custody, care and control of their carers. I know of specific instances that I won't comment about on this video of 5-year-old children being manipulated by DOCS officers to say that people have been sexually tampering with them, and that whilst the children sit there and are very clearly saying that what you are saying is a lie, the DOCS officers continue to try to put words in the mouths of 5-year-olds. Now, this is not the sort of thing that this country is based on. These people need to be weeded out. This department needs to be shut down. The minister responsible needs to be hung, drawn and quartered. And there needs to be some equity put back into the process of children who are not being cared for, being properly cared for. Children that are being properly cared for by their parents should never be removed from their parents. Why do docs walk into hospitals and take babies from mothers 4 days old on the basis of something that their parents might have done 10 years prior? Where does the concept of being forgiven in this society go? You mean to tell me that a person can't do something when they're 18 years old, if they have a child when they're 25, that still has to be dragged up and used against them if they've no repeat history or no other record? I don't believe there is ever a grounds whereby the state should ever have the right to come and steal a child, regardless of how they do it, to steal a child from its parents. And I know there's going to be a lot of the government will pay people to come out and go, oh, but you've got to do this, you've got to do that, because the government will do that. But nonetheless, when there are issues of grievous treatment of children, where's the government? Where are these kids like the ones who get starved to death and nothing's done until, oh, hang on, the child's been dead for 3 weeks. Oh, gee, we screwed up somewhere. And the same docs officers at the same time that was going on were out pursuing parents whose children were perfectly normal, perfectly healthy, very well educated. They just weren't educated in the system, or they weren't registered, or they weren't vaccinated. For crying out loud, let's get our priorities right here, right? That's the sort of things that we need Australians to stand up and move against. If our government is our government, if it is, which it's not, but anyway, if the government is of the people, for the people, and if the government is there to represent our position and to make laws and amend laws for our benefit, then they need to start doing that for our benefit, to stop taking... Have a look at what's going on in the prison system. Half of the blackfellas in the prison system are there because they don't have a licence to drive a motor vehicle. What? Families are broken up, children, then they come and take their children off the mother because the father's in prison because he didn't have a licence and he was driving a car. Hey, you guys built your roads on our song lines. Don't forget that. And if we want to travel our song lines to get to where we're going to do our business, that's our prerogative as sovereign people, like it or lump it. There has to be a better reason to lock our people up. Our people are incarcerated at 15 times our representative in the population. Yeah? We make up 2% of the population and 30% of the prison population. 50% in the Northern Territory. It's an absolute joke. When's this going to change? It won't change until the government believes that they don't have to keep knocking us down to hide the fact about sovereignty. But that'll never happen because we are still the sovereigns, we always will be. We need to start doing things about telling the truth about who actually owns this place and the law on this land. We need to start doing things about maintaining the family unit rather than dividing the family unit. And we have to do things about starting to make laws in this land that are laws that have a benefit to the community, not a detriment. You can't tell me that it's appropriate that just because someone can't read and write, they shouldn't have a licence to be able to manoeuvre and drive around the place the same as anyone just because he can read and write. And that he should be picked on if he's driving up the street, that he should be picked on simply because he's got black skin. The copper should have the right to turn around and nail him for something. I don't think so. And all this stuff's got to stop. You know, do we live in the Australia we believe in, or do we live in an Australia that we think we believe in?